Hello everyone and welcome back to our channel. My name is Malescu and I am the owner of Malescu Law, a law firm based in Miami, Florida, specializing in business, corporate and US immigration. We can assist you with all your immigration needs regardless of where you are currently located or where you plan to go in the United States. Today we are going to speak about the L-1B visa requirements for employers and employees. But before we get started, please subscribe to our channel by clicking the bell button or the subscribe button. The L-1B visa is a visa option for US companies seeking to transfer employees with specialized knowledge from their affiliated foreign office, whether a parent, subsidiary, branch, or affiliate to the US office. The L-1B visa is specifically designed to transfer employees, so for international transfers of employees within multinational companies, meaning companies with offices in more than one country, in order to bring their expertise to the United States. The L-1B visa requirements for employers and employees. In order to qualify for the L-1B visa, both employers and employees must satisfy all of the following requirements. 1-year employment abroad. The employee must have been employed abroad for at least one continuous year in a position that requires specialized knowledge within the 3 years prior to their transfer to the United States. Now, days spent in the United States will not count towards the 1-year requirement, but will not break the continuity of your employment. This means, for example, if in the past 12 months that you were employed abroad, you took trips to the United States, those days that you've spent in the United States do not count towards you meeting the 1-year requirement abroad. So effectively, you will need to continue working abroad, being physically abroad, working for additional days in order to cover up the days you've spent in the United States. So you will need to work more abroad in order to make up for those days that you've spent in the United States. However, the good part is that your days spent in the United States will not actually end the continuity, so it will not restart the 1-year clock again. A second requirement for the L-1B visa is qualifying corporate relationship. This means that the US company and the foreign company must be part of the same organization, meaning that there's a qualifying corporate requirement between the US entity that will sponsor the L-1B visa employee and the foreign employer, and they can be related as a parent, subsidiary, affiliate, or branch office. A third requirement in order to qualify for the L-1B visa is that both the US company and the foreign company must be doing business. This means that both the US entity and the foreign entity must actively, regularly, and systematically provide goods or services in the United States and at least one other country for the duration of the employee's stay in the United States in L-1B status. So they must have active operations, both the US entity and the foreign entity, and not simply have an agent or an office in their respective countries. You will need to have, the entities must have actual, real, active, regular and systematical operations in these countries in order for them to be deemed as doing business in their respective countries. Simply having an office or an agent in a country will not qualify as doing business. And now the fourth requirement is that the employee has worked in a specialized knowledge role. So the employee must have been employed abroad in a specialized knowledge capacity. And the final requirement, the fifth requirement, is that the employee will be coming to the United States again to fill a specialized knowledge role. So the employee will be transferred to the United States, and in the United States the employee will render services again in a specialized knowledge capacity. Now, aside for the 5 requirements we spoke about in order to qualify for an L-1B, if the US entity is a new office and is looking to bring an L-1B employee to this new office, either for the employee to establish the new office or to join the new office, then there are 2 other criteria that must be satisfied. So this will only apply for those US companies who have been doing business in the United States for less than 1 year. In this case, where the US entity has been doing business for less than 1 year in the United States, the entity must satisfy 2 additional criteria. And that is 1, sufficient physical premises. So the entity, the US petitioning entity, must show that it has obtained sufficient physical premises, it has secured sufficient physical premises in order to host the new office in the United States. And the other requirement is that it has financial ability to cover the salary of the L-1B employee and any other employees the company has, and also has the financial ability to start the operations in the United States and finance those operations in the beginning. Now, for this requirement, it is also possible to show that the organization itself has the financial ability to pay the salary and start business in the United States by using the financials of the foreign company. So the foreign company can actually pay the salary of the L-1B employee and the employees in the United States initially, and through the financials of the foreign company, you can also show that it has the ability to start the operations in the United States. And in this case, you will use tax returns and other financial documents to prove the company's ability to cover these expenses. Also, it is possible to use the financials of the US company in order to show the ability to start operations and pay all the salaries, including the salary of the L-1B visa employee. This is all for today. Thank you so much for watching. Please subscribe to our channel, and if you need to get in touch with us, you have our contact information in this video and below this video. We will see you soon. Bye.